It's a difficult task to follow Mr. Desai after his extensive speech, which covers almost everything that one has to say of any significance under the BNS. And I also noticed during his entire speech he didn't refer to the full form of the new act. He conveniently chose to refer to it as BNS. And I was sitting there and wondering whether it's one of the two reasons. That mentally he wants to replace IPC with BNS, or the other one, that maybe sometimes he'll falter in pronouncing this. So following his act, I'll also stick to saying it as BNS. So I don't think there was any requirement for bringing a new code of the IPC. There just was not. And that is proved by the fact that the BNS just reduces the number of sections, and it reduces them in a manner that if you have a look, that suppose under a particular offense, like robbery, there were various sections dealing with robbery. They've all been consolidated. Those sections have been consolidated and put under one section as the subsections. The sections remain the same from IPC, but they now become subsections. Likewise, you have under for dacoity, and they have compressed the sections so as to reduce the number of sections. The definitions by and large remain the same also. So substantively, if you were to ask me, is there any difference between, aside from the sections that Mr. Desai mentioned about the new provisions for organized crime, petty organized crime and terrorist act, are there any substantive differences between the IPC and BNS? One would just have to answer and say, no, there isn't. What is even stranger is that, and shows a slight, I don't mean to be disrespectful in the manner that it has been done, what is even stranger is that the illustrations from 1860 have been retained in the illustrations that we are giving to the definition of offense in 2023. So if you have section 300 of the old IPC, which is murder, definition for murder, which is now section 100, and you have fourthly, which is an act which is so eminently dangerous, and in that you have an illustration that A fires a cannon into a crowd. That definition is retained under BNS. A fires a cannon into the crowd. Now there are no cannons, firstly. I don't think anyone has a cannon in their possession. You may have fired, except for military areas or naval areas or where they have to, for gun salute, maybe that. But there are no cannon available for somebody to go, there is a crowd, yes, let me fire this cannon into a crowd. No. You could have possibly applied the mind, whoever was suggesting these changes, could have applied their minds and said that whoever takes a light machine gun or a machine gun and fires it into a crowd, weapons that are more ordinarily available now in 2023 than what was ordinarily available in 1860. That is one such illustration that I just want to give. Or A shoots at a fowl, that is a bird, a fowl. Now, if you shoot at a fowl, you will be prosecuted under the Wildlife Act. So there is nobody is going to shoot at a fowl, which will be mistaken that if a bullet hits somebody else. So there is the small amount of non-application of mind. If you are trying to make an act more applicable to the present time, and you were enacting it, the parliament that is, some amount of thought process ought to have gone into it to make it more relevant for the present time. That is one. The second aspect is there are various things which were prevalent in 1860, which have been retained in 2023, apart from the illustration that I gave. there is always a difference in, according in the times in 1860, of suppose house trespassing at night. Night was very a period in 1860 before electricity etc. came into being, modern electricity, where there was complete darkness. So offences which were committed at night, for it was difficult to prove who committed those offences, were made more stringent than offences that were committed in the daytime. The BNS retains many of those distinctions of night, only to clarify that it is after sunset and before sunrise. So night is clarified by after sunset and before sunrise, but the offence remains by and large the same. For reference, it is now you have a 309(4), which is punishment for robbery between sunset and sunrise on a highway, which was earlier 392, which said that if there is robbery at night, then you have a more stringent punishment for it. Then you have like for accordingly for that. And one other aspect that I just want to mention in passing is, of course, this will be covered in the topic tomorrow, is that many of the sections here which continue to provide for imprisonment for life. So you have the earlier 409, the equivalent of which you have now, because I'll have to keep cross-referencing, is 316(5), which is criminal breach of trust. The punishment is for life. You are punishing somebody for criminal breach of trust. That has a history which I'll just address, and including the forgery aspect, which was 467 earlier, which is now 338. That is also punishable for life, of a valuable security, etc., for life. So in the olden days, in the British time, forgery, etc., which led to the trial of Nand Kumar for hanging, death by for forgery, you have retained, or the Parliament has retained, the extreme punishment for life, which would now be equivalent to something like murder, for forgery and for criminal breach of trust. That is one aspect of it they have certainly overlooked, because the punishment should have followed the normal cheating, either 7 years, you can make it maximum 10 years, etc. But to punish for life, and mind you, I checked the CRPC, or the new BNSS, the new BNSS, I checked that it continues to be tried by magistrate of first class. So it is bizarre, because if one is having an overhaul of these sections, firstly reduce it to that which is tribal. If you want to retain it to be tribal by a magistrate's court, reduce the section, because the punishment, the amount of punishment that the magistrate can give even under the new code of the BNSS is about the same as in the Code of Criminal Procedure. So these are all, this shows that yes, one wanted to overhaul the acts that existed. Fine, nobody can stop the Parliament from doing so. Maybe the motive was very good, we need to have a new act. Yes, it is. But it also shows a non-application of mind, that if you are retaining the lacunas or problems that existed and have plagued from 73, or even according to the 1898 code, plagued the judicial system, then address it, but it's not been addressed. The other aspect is what Mr. Desai spoke of, is the introduction of the 3 new offences which are standing out somehow in every criminal lawyer who goes through it, is organized crime, petty organized crime, and terrorist act. Surprisingly, all the 3 have been introduced in the chapter of offences affecting human body. Now, how does organized crime, petty organized crime, and terrorist act affect the human body? Yes, it does in part, because murder is a component that may be there in continuing a terrorist act, and even in causing bodily harm as far as the organized crime is concerned, not petty organized crime. But how does it fall under the chapter of offences? Because in those chapters, the ingredients of those offences, and as was touched upon by Mr. Desai, the organized crime is a direct lift from Makoka. Makoka, Gujkoka, Makoka is applicable to Delhi, because Delhi has made it applicable. It's a direct lift from Makoka. And the Terrorist Act is a direct lift from UAPA, the amendment that came in section 15 as far as UAPA is concerned. So there is nothing new about that. You are not defining it in any manner. In fact, the definition of UAPA of Terrorist Act in UAPA and now under BNS is such that somebody who causes a terrorist act abroad to which India has some friendly relation or some can be prosecuted in India, which has no other connection except for that country where that terrorist act is being caused. So that creates some amount of a break in the link as far as the person in India either conspires or does a terrorist act abroad but will be prosecuted in India. So those are, and that was a problem, that is a problem which is there in section 15 of the Terrorist Act, where persons from India went to join ISIS to fight a country. This was not a fight that related to India, but fight in Iraq or wherever they went in the Middle East to fight, were prosecuted under UAPA in India. So one of the arguments that was taken is, look, there has no causal connection between what I am doing there as far as India is concerned, because I am not causing any harm to India as its sovereignty or integrity of India is concerned. But of course, that lacuna also continues to remain. Now, apart from these three being part of the Terrorist Act, which of the Terrorist Act and organized crime and petty organized crime. Now, petty organized crime is a very it's a sort of a section which has no utility in any manner, except because every person who's committing those petty offenses in any case would have been prosecuted for theft or snatching or some of these offenses that are being carried out. So to have a special section that would prosecute a person to show that yes, there is a petty organized crime, that petty organized crime or a gang carries out activities like snatching or theft, and therefore they are to be prosecuted under the new section, does not sort of make sense to put it as a separate section itself. Apart from that, all these three, there is also an issue of solitary confinement, which is there as one of the punishments under the Indian Penal Code, has been retained in totality under the BNS under section 11. Now, solitary confinement, as we are proceeding towards a more, as we keep saying, a civilized manner of living or a more civilized manner of living, solitary confinement, it is known clinically and by experts, has a very deleterious effect on a human person. The period of solitary confinement remains the same under the BNS. However, the retaining solitary confinement as a punishment that the court can award, especially when we are moving towards a situation where cruel and unusual punishments would not be awarded, is a sort of a lacuna which is also ought to have been addressed by the Parliament. Then there are some good things, which is like 310 and 311 of IPC has been done away with, which was thugs. Now, thugs was a sort of a term given to people of who used to catch hold of people on the highway and would commit offenses against them. So thug was a word which was not of a very good context. So that has been deleted. So let's not say that's all bad under BNS. Thugs have been deleted, and attempt to commit suicide under 309 also has been removed. Apart from those, there is a punishment that has been added called community service, which is a good thing. Suppose in smaller offenses, if the court is of the opinion, when we argue in court that invoke the Probation of Offenders Act under 360 of the CRPC, we used to say the court can award in smaller sentences community service to a particular person, so as to the person need not have to go to jail or custody to serve out, and that's a good, more humane approach as far as addressing the offenses and punishing for the offenses are concerned. Now, in all of this, the problem that will be caused for the next 20 to 25 years is that, of course, we as lawyers and everyone by the time, especially in the Supreme Court or in the High Court, the problem that will, by the time it travels up there, we will have all the barracks, etc. But imagine a situation in the talukas, imagine the situation at the district level, imagine in the situation in remote levels, imagine the police. Now, by criminal lawyers by the very, because it's not, they generally master just a manual. They just have three, CRPC, IPC and Evidence Act, and they don't need any other books. They just carry this everywhere, wherever they go. And over by period of time, you remember the sections. Unlike civil law, which is much wider, it's about 70% of our lives are governed by civil law and 30% by criminal law. The sections that are going to be imposed are going to be completely different. So we are relying upon the registration of the FIR under the new sections, under BNS, and I'm told that it's from 1st July it's going to happen. So the police officer should be well aware in a remote area about the new sections, because he can't go back to the IPC, which is the ordinary. The lawyer arguing for the first time before a magistrate on a remand or for bail has to be aware of the new provisions under the Act. When it travels up to the sessions, likewise is the situation. Travels up to the High Court, likewise is the situation. And by the time it comes up to the Supreme Court, as Mr. Chandiok said, it's good for some of the lawyers, or some of us, for the lawyers, because we just have to get up and say, this section has not been interpreted because it's a new section and it requires interpretation. And so the court should address it and start interpreting. So it's a valuable waste of time, according to me. The third thing about the problem with this is, it seems to have been, and this is my reading of BNS, is the reason why they have relocated the section. I would have not had much of a problem. You can call it BNS and you can keep the sections as they stood, because everyone knows 302, everyone knew 376, everyone knew 420. I mean, 420 became a sort of a mimicry even in court. Kya tum 420 ho, so sort of a thing it got for cheating. Everyone knew those sections by then. It didn't require going to a book and referring it to them, and kept the sections as it is. But what seems to be the flow, and if you go through the index, as I went through the index, the emphasis of the parliament is that we will address first the protection of women and children. That, according to the parliament, seems to be of primary importance. Therefore, that falls as the first offences, apart from abetment, etc., and general exception chapter that is there. Not offences against state, which was there in the IPC. Thereafter is offences affecting human body. So women and children and human body have been given priority over other sections, which were offences against public tranquility, offences of against state, offences, obscenity, etc., which were there, which preceded up till section 299, which preceded the in the IPC. And from there it goes down and goes to the least of the provision. Intimidation, insult and annoyance continues to be the last there. But in that manner, it has given precedence to offences affecting human body, and last to the monetary, etc., aspect of it, which is cheating and forgery, etc., which continue to remain at the back of this. So yes, it's a noble thought to address that the human body, offences against human body should come first, but it's also causing a lot of problems in the minds of the people who have to work this act, the new act. Not only the lawyers, who of course will ready themselves, but the police, the judges, of course, and various other stakeholders who are there. Now, apart from, very briefly, from touching these other aspects, what I said is the merged sections also in their own create a particular problem as far as the cross-referencing is concerned. Because when you look at the books, which will have, and we used to have this earlier also, now it had stopped, that when the new 1973 code came, it had provided every BAI Act of the CRP, every BAI Act used to have a cross-referencing section right at the beginning itself. Now, having a merging section just because it deals with one offence of one kind does not necessarily make it very convenient to everyone, because you have to then go on reading the new section and finding in that subsection what was as a proper section in the IPC. I'm only pointing out in a manner of the working and the problems of this BNS that are going to occur from 1st of July of 2024. So we all will have a lot of work to do as far as working this is concerned, because you have to then search by not only by looking at the cross reference, you are not going to be able to make out whether that particular section is there in so many words or not, because you will get, suppose robbery, you will get only robbery as the sections in the BNS, but some other ingredient of which was a separate section under IPC, you will only get it as a subsection. So that also involves a lot of work. Now, apart from all these problems that are there, it does, in my opinion, does not in any manner or immensely or greatly simplify the definitions. We have been since 1860 dealing with, and the courts and replete number of judgments of Supreme Court, forget the High Courts, of the distinction between culpable homicide and murder. Now that is one area where we have been dealing, and every argument, not every, unless it's open, like 3 dead and 4 injured in broad daylight incident, which is murder itself. But those slim distinctions that we had, I would have expected the Parliament and the stakeholders before the Parliament, the persons who advised on this BNS, to have worked out a better distinction between the two offences, because if you were to compare 299 with 300, almost all the ingredients are the same except for the knowledge part, which falls under 299. It is not there in 300, and that takes you to culpable homicide. So it would have been better if more clarity had been accorded to sections which are there in use for every day, because murders are committed every day and murders will continue to be committed every day till humanity exists, unless we reach some sort of a utopian existence. It will continue. So clarity there. Punishment is also there. Now attempt to commit culpable homicide, because there is a view amongst the jurists that culpable homicide by itself is not an offense. It does not, you can't be prosecuted by it. There is a view amongst, and sometimes judges also react when you are arguing to, no, culpable homicide is not, it's murder, and only the exception, then you fall under 304. But there is an attempt to commit culpable homicide, which is there in 308 earlier, has been retained as it is in the new code. So a lot of this, and forgery and false documents, complicated sections. They are complicated sections and have been retained as it is in the new, in the BNS. So according to me, the BNS still requires a certain amount of work still, even though it's just been brought in. But like all legislations in India, and Mr. Chandiok would vouch for it, like the Arbitration Act 1996 has undergone more amendments. I've never seen a slimmer act with more amendments than the Indian Arbitration Act, because it just goes on amending. So maybe the Parliament, and as the problems arise and the interpretations arise in BNS, maybe the Parliament will be aware of the amendments to make in the manner that has been suggested. But above everything else, I would have been happier, and I'm sure a lot of you would agree, had the sections just remained to be numbered as they were numbered, and then made the changes by addition, Terrorist Act or whatever acts that are there. I'm not commenting or going deeply into the Terrorist Act or Organized Crime Act or organized offences, which is now separately made an offence because Mr. Desai touched it. And but yes, it is. They are very wide. They are open to a lot of misuse by the police authorities in the states, because they are so wide in their interpretation that any and every activity can be brought under the Terrorist Act or Organized Crime Act. And it is only on the ipsi dixit of an investigating officer who, if he has a grudge, or as we all know on the criminal side, who has a grudge against a particular person, can simply invoke this section, and you are in for a long time, because securing bail, now jail and not bail is being the rule. Securing bail or getting out or proving your innocence is a tall ask in these days. So keeping such wide definitions, which are already causing problems in the, then the other part, just before I leave to the other speakers, the other part is, what about, can it be punishable under two offences? So somebody invokes, in Maharashtra, you have Makoka, invokes Makoka as far as, and also the Organized Terrorist Act under this section 113 of the IPC. Both have been invoked against a particular person. Of course, one will rely upon the general clauses that if it's an act under 2 sections, you can be tried under both, but you will be tried under both the sections. I'm just pointing out the enormity of what will happen. So there is the MACOCA, UAPA section 15 and section 13 of the 113 of the BNS for a terrorist act for a person to be tried. So my endeavor was not to, because it's not possible to go into the definitions, and this is not a class or a lecture or anything in that sort. It's only to point out the pitfalls and the problems that are going to arise in the working, and these, according to me, are some of the problems. Many of the problems we will all discover when we are addressing the courts in our matters that we are addressing as lawyers, in the interpretation that will crop up. And yes, it will cause for the next 20-25 years at least, till the last of the cases under the IPC is resolved or dealt with by the Supreme Court, that we start only with the BNS. So I'm really grateful to the Bar Association for this opportunity to address all of you distinguished people, and thank you for your time.